Whenever I hear alleged and putative legal experts talk about the Diddy case, I ask myself one simple question. What is it? What is the Diddy case you're talking about? Because this guy is either going to be acquitted outright, there will be a judgment of acquittal granted, almost a directed verdict, if you will, by the trial judge, or he will be reversed on appeal. Because the unfolding drama, this cacophony of irrelevance and sick behavior, has nothing to do with the charges filed. The unfolding legal proceedings involving Diddy have drawn, as you can understand, considerable public attention, but for reasons that are increasingly disconnected from the actual charges at hand. This is a fact people don't seem to pay attention to. As is often the case with celebrity trials, particularly those involving allegations of a sexual nature, the courtroom has become not merely a forum for the adjudication of facts and the allegations and the presentation of evidence, but a stage for the performance of social narratives and cultural grievances and prurient, sick curiosity from a bunch of babies who apparently have the sexual sophistication of an infant. Okay? Everything shocks them. Baby oil? What? Baby oil? It's incredible. Now, at its very core, the concern is this. The trial has evolved into a wide-ranging spectacle, this sensationalistic expose, where the prosecution has permitted and perhaps maybe encouraged a wide swath of testimony and evidentiary detail that, while salacious and scabrous and concupiscent and headline grabbing and, oh my God, and sick and sordid, it appears tangential at best, if not completely irrelevant. Irrelevant to the legal elements of the three charged offenses. Now, you have to, again, I'm saying this, must distinguish between conduct that is offensive, morally reprehensible, morally questionable, conduct that is sickening, and conduct which is criminal under the law. The two oftentimes have nothing to do with each other. You could do the most demented of things between two consenting adults. The American legal system, which is rooted in principles of due process and evidentiary fairness, demands that a defendant, any defendant, be tried not on the basis of his character or the character reputation of others, but on the narrow, constitutionally bound question of whether they committed the alleged offense charged in the indictment. That beyond and to the exclusion of every reasonable doubt. And what has transpired in the courtroom, bears the markings of, for no other reason, prosecutorial overreach, where the case has been inflammatory testimony regarding Diddy's sexual predispositions, proclivities, his lifestyle, relationships, and whether they've been violent or not. What does it have to do with violation of the Mann Act, sex trafficking, and having a racketeering enterprise? They've taken center stage. They've overshadowed the specific elements that the prosecution must prove, and only that, to sustain a conviction. Is this going to be Harvey Weinstein again? You know, the risk in this approach is substantial. Courts have long recognized the prejudicial impact of introducing bad character evidence or evidence unrelated, this is 403 evidence, unrelated immoral conduct, to sway a jury emotionally rather than intellectually. The Federal Rule of Evidence 403, mirrored in many jurisdictions, allows for the exclusion of evidence, even if its probative value is there, but is substantially outweighed by the danger of unfair prejudice, confusing the issues, or misleading the jury. That's what they're going to hang the appeal on. Here, that danger has materialized in full force. I mean, it is radioactive. And witnesses have testified to events that span years, some of which are temporarily and temporally, I should say, and substantively disconnected from the indictment. The introduction of allegations involving third parties, non-criminal conduct, or consensual relationships and hookups, however unconventional and weird and freaky in the freak-offs, does little to illuminate whether the specific conduct alleged in the charges in the indictment occurred in a criminal fashion. And more troubling is that much of this testimony has not been challenged under evidentiary motions or motions in limine, or nor adequately limited by the bench, in essence, allowing the jury to conflate lifestyle with liability. Now, of course, I'm not there and we're not there, so we're kind of assuming a lot of this. Maybe this has been done, but I don't think so. And furthermore, media coverage, often unfiltered and unanchored from procedural nuance and unconnected, and basically, they created an echo chamber where the line between allegation and conviction has completely been blurred, totally blurred in the public's minds. This is sort of a kind of a pre-verdict conviction by press, precisely what the founding fathers hoped to avoid when embedding the presumption of innocence and the Fifth Amendment into the legal fabric of our beloved jurisprudence. If you think that's highfalutin talk, you're not paying attention. The prejudicial spillover from media sensationalism into the courtroom cannot be ignored. And the defense's task, that's right, Diddy's defense, doubly burdened. Not only must it rebut the charges, but it has to also fight to reorient the jury's focus back to the legal questions that matter. Whether Combs engaged in behavior that is distasteful to jurors, or media commentators, or society at large, is irrelevant, immaterial. It's not germane unless that behavior falls squarely within the statutory definition of the offenses charged. It's that simple. Jurors are instructed, though they may, they are instructed, we hope, to disregard prejudicial evidence, but they're human. And the volume and the intensity of character-based testimony in this case threatens to impermissibly taint and distract and influence their reasoning, which would in essence transform what should be a narrow criminal inquiry into this referendum on the lifestyle of Diddy. Should a conviction be obtained under these circumstances, the likelihood of an appeal, a successful appeal, and a viable one, is substantial. Appellate courts review not only legal errors, but also whether a defendant received a fair trial, free of undue prejudice. They pay particular attention to evidence admitted over objection, evidence which is inflammatory, that contains also prosecutorial arguments which cross the line, or judicial errors and missteps in managing trial fairness. If an appellate court, the Second Circuit in this case, concludes that the cumulative effect of irrelevant, prejudicial evidence overwhelmed the jury's capacity to decide solely on the facts relevant to the charges made and the offenses alleged, a reversal is not merely plausible, it is likely. Put your money on it. A parallel can be drawn to numerous appellate reversals where courts found that evidence of prior bad acts or moral turpitude, when not directly tied to the charges, served only to, in essence, taint and poison the jury's view of the defendant. Now, the law does not permit a conviction merely because the jury finds a defendant unsavory, or unlikable, or morally bankrupt, or weird, or freaky. It must find that the prosecution met its burden with evidence that speaks directly and persuasively to the offense charged and nothing more. And moreover, a motion for acquittal under Rule 29 of the Federal Rules of Criminal Procedure, or its state-level equivalent, could be warranted at the close of the government's case if the government's case relies excessively on innuendo, unrelated acts, or peripheral issues, and fails to present a prima facie case, fails to present evidence sufficient for a reasonable jury to conclude guilt beyond a reasonable doubt on the actual statutory elements adduced. Then such a motion is not only viable, it becomes necessary to preserve the integrity of the process. To the lay observer, the trial may appear to be about getting justice or exposing the truth. But trials are not cathartic exercises, nor are they platforms for social or moral adjudication. They are legal proceedings, specific legal proceedings, governed by specific statutes and specific rules of procedure and evidence, burdens of proof, and constitutional constraints, I say to you, ladies and gentlemen of the jury. Prosecutors have an ethical obligation, and the court as well, not to seek convictions at all costs, but to ensure that justice is done. And that includes the discipline to exclude what is inflammatory or marginal, even if it pleases the press or the public. The defense, on the other hand, must rigorously protect his rights, Diddy's rights, not just to defend against the charges, but to demand that the process itself remains fair, bounded, contained, and rational. And that includes calling out prosecutorial overreach, filing timely motions, objecting, striking irrelevant testimony, requesting motions in limine instructions, and building a clear appellate record. It must be absolutely remembered that public figures, even Diddy, are uniquely vulnerable, my friends, in this system. They're often assumed and presumed guilty by virtue of their wealth or past behavior. But the presumption of innocence is not just an expression. It's not a luxury reserved for the obscure. It is the bedrock, the abecedarian foundation of American criminal law. And it does not evaporate when the accused is famous. In sum, my friends, while the charges against Diddy Combs are serious, the way they are being litigated raises more concern than confidence. And this conflation of lifestyle with criminality is not merely bad trial strategy, it is legally perilous. If the prosecution cannot discipline itself to focus solely on proving the elements of the charged crimes, the result may well be either an acquittal by a jury who sees through the theatrics, or a conviction that does not withstand appellate scrutiny. Either outcome, my friends, either outcome should not surprise anyone. The real surprise would be if such a trial, with its carnival of irrelevancy and prejudicial distraction, were allowed to define modern justice without challenge or without correction. And that is what I say, my dear friends. Your thoughts and comments are so appreciated. Please, please, please subscribe to Lionel Legal. Like this video. We need your metrics to continue our great work. I thank you for watching. And please go. I've got some questions for you to answer in the comment section. I'm curious as to your follow-up. And pass this on. Let others see what we have to say as you comment, as you see fit.